All right. Okay. Thank you, everyone, especially people online. Welcome to this SIPL seminar. My name is Henning Gross-Roos Khan. So I should be looking up so that people online can see where I'm looking. I'm one of the members of SIPL, and I have the great pleasure to introduce our speaker for today, which is Professor Madieha. And Ida has been a good friend and colleague for more than 10 years, I think. We have been collaborating in Malaysia and now here in the UK. Ida is currently visiting Cambridge and is here today to give a talk on revisiting personhood theories and effective AI legal frameworks, looking at contemporary discourses as well discourses in the Muslim world. So without further ado, Ida, please, you have the floor. Thank you.
Thank you, Henning, for the nice introduction. It is really my pleasure to be here today to share my thoughts on a very important discourse, which I think almost every IP professors and almost all IP students are indulged in. I would also like to express my deepest appreciation to the Center of Intellectual Property and Information Technology for this precious opportunity to share my thoughts on the existing discourse on effective AI legal framework. Particular thanks to Prof. Henning Gross-Khan for hosting me in Cambridge. And at a personal level, this trip is like a comeback to Cambridge after completing my LLM in 1991. What I will be sharing with you is an abridged version of my paper for the Gulf Research Meeting on Artificial Intelligence held here in Cambridge itself in July this year. So that was just a couple of months back. This discussion could not have been held at a more opportune time with the convening of the AI Summit that UK hosted yesterday that talks on potential threats to national security posed by AI. The summit addressed issues which most nations, Malaysia included, are concerned with, particularly on the need to have a robust governance and accountability mechanism. Malaysia is also in the midst of formulating legislation on AI ethics and governance. In this sharing session, I would like to revisit the need to have an effective AI legal framework and whether this would necessarily involve the recognition of some form of electronic personhood. On this note, I would like to share my thoughts on corresponding discussion by Muslim scholars on artificial personality. I must say I'm quite nervous in getting this talk right, that I write whatever I need to say so that it is said rightly and I say the right thing. Now, within these 30 minutes, I will start with the EU position on civil law rules on liability and suggestions on how to address liabilities arising from AI transactions and activities. I must stress, however, that this discussion may be in the knowledge of many people in this hall already, bearing that these issues have been discussed in this region for many, many years. The talk then moves to cursory look at the discourse on AI personhood. Again, what is being touched here is just scratching the surface. I must say, over the last few years, this area has attracted an enormous amount of research that it is impossible to cover them adequately. But I have to say that I have benefited substantially from my stay here in Cambridge because I end up reading more and more on AI personhood, particularly the book written by Cambridge University Press, the Cambridge Handbook on Artificial Intelligence. Thirdly, I would like to draw the attention to the Muslim scholars' debate on the liability gap. In this context, allow me to draw analogy with the previous discussion on corporate bodies as legal artificial entities within Islamic scholarship. I would like to start the discussion by drawing our intention to the European Parliament resolution on civil law rules on robotics that calls for the creation of specific legal status for robots. For what type of robots? For sophisticated autonomous robots. For what purpose is it? to make responsible for making good any damage caused by these emergent technologies. For me, this is a noble policy objective and a very good way forward. This is followed by a report by an expert group on liability and new technologies in 2019, which indicated that there is no need to confer legal personality to emerging digital technologies, as harm produced by them can be attributable to natural persons. This is accompanied by concern that any additional personality amount to putting a cap on liability, and there may be subsequent attempt to circumvent such restrictions. This is followed by an EU Parliament resolution on October 2020, again stressing on the need to focus on humans behind the system, and any kind of liability would be attributed to this person. A further report by a study commissioned by the EU Parliament attests to this notion that there is no philosophical, technological, nor legal ground to consider the robots anything but artifacts generated by human intellect and then products. Slide 7 and slide 8 further reinforce the idea that the liability gap can be addressed by identifying the human being who might be responsible for damages arising from the use of the device. Though the report leaves the possibility of introducing a fictitious form of legal personality to specific class of applications, that statement itself is enough to get many people excited. Those EU resolutions and reports somehow does not put into rest the inquiry as to whether an artificial intelligence could be vested with personhood. In 1992, Lawrence B. Solomon has loudly enunciated that in 1992, I repeat, this question is only theoretical. I believe many of us here are of the opinion that this is still true, but that does not stop academics or even like people like me and you to discontinue the inquiry altogether. That leaves this issue as to who and what can be a legal person. The easiest start is Black Law Dictionary that defines it to be any being whom the law regards as capable of rights and duties. That leaves the issue as to whether that is only confined to only natural person. This leads to the substance of this discourse. Many academics focuses on what makes a person. What if this intelligent system possesses natural or human-like behavior? Does that make the system human or human-like, thus deserving to be treated as a legal person? I have read many articles that identify important attributes such as intelligence as one important factor. Others attribute ability to make independent decisions. I have also heard that in the future, AI will be sentient, that it will achieve a level of consciousness, but we all know that this is only claims. In Malaysia, we have AI radio DJs that are capable of making conversation, crack jokes, as well as banter with each other. But does that make these AI DJs anywhere near humans? What about creativity and inventiveness? Are the AI's creativity and inventiveness capable of being identified as, being created by human for purposes of intellectual property law? I'm sure some of you have heard the new Beatles song just released in the afternoon, and I happened to be in my room listening to the news when the song was really released. And it was made possible with AI. Using AI, John Lennon's voice from an old demo, the new and final Beatles song was created. And me being a big fan of Beatles, of course, stay and saw the whole thing this afternoon. Now, the discourse of extending legal personality to passive legal persons, non-human entities, and inanimate objects is nothing new in the history of legal scholarship. We can read cases involving animal rights action and the concernment of recognition of inanimate objects such as Wanganui River in New Zealand and several rivers in India, which have been done to achieve specific objectives. And I suspect this to further climate action as well as for animal rights. I would have thought that the most comprehensive work on AI personhood is Visa A. Kurki's work on legal personhood, animals, artificial intelligence, and the unborn. For him, the most important inquiry is what does it mean to be a legal person or to be recognized or treated as such? The main distinction is that of the person or thing distinction. In his seminal work, Kulki examines many theories of personhood, tracing back from the ancient world to the early modern era and the birth of orthodox views to Hoffeldian analysis. Kulki's main contention is that legal personhood is the nexus between a legal person and being able to have a legal role. Following the bundle theory, legal personhood is the cluster property that consists of a bundle of active and passive incidents that occur to such entities. Such incidents are discrete legal rights, responsibilities, and competencies by legal person. In his final analysis, he framed three important contexts by which AI should be measured: the ultimate value context, the responsibility context, and the commercial context. These three different important contexts place AI, to him and in his estimation, closer to legal entities. Again, this is based on hypothesis that the AI system that we're talking about is a strong AI system. We now move our discussion on the potential liability caused by AI under Islamic law. We find that there are three corresponding issues appearing. Is the AI seen only as tools? If it is so, then the responsibility lies to the user of the AI. Secondly, does the AI act as an agent to the human? In this case, the concept of wakalah or agency will apply. Thirdly, does the AI act as an independent actor? In that case, can the AI be personally liable for the harm caused? Like in contemporary scholarship, the religious views of personhood stems from the Quranic conception that human is God's best creation. Ontologically, a human is described as hayawanun natiq, or the living being that speaks. Prof. Nakib Alatas, for example, described a human to consist of the articulate soul, the intellect, the roh, or spirit, and the qalb, or the heart, i.e. spiritual perception. So from the religious point of view, personhood occurs when ensoulment happens, when a human is old enough to bear responsibilities. Man is endowed with free will so that he can live his life according to his free will. And this is the basis of personhood from religious prescriptions. Opinions from other Muslim scholars seems to suggest that the main distinction between a human, apart from other creations of any sort, is the mental and rational element. The theory of personhood in Islam is grounded in its religious prescription that personhood is not limited to just cognitive abilities, but a combination of soul and thinking abilities, or known as akal, or further described by Ibn Sina as a spiritual or immaterial substance, not a physical one. From the perspective of legal rights and duties, legitimate rights and responsibilities must derive from main sources of Islamic law, i.e. Quran and Sunnah. Scholars are saying that both the right holder and the recipient of such rights must be natural person. Similar to the Western view of personhood, once a person is endowed with legal status, all rights and obligations follow from his conduct. Therefore, what follows is the question of sins and accountability for one's actions. On this point, Hassan al-Basri propounded that personhood means the ability to live one's life according to his free will. Now, although in the Islamic world, a man is free to live his life, but he has to follow guidelines and laws prescribed by the religion. Therefore, with this comes another requirement of personhood, i.e. free will. The discussion of free will is extremely crucial, and it is the main prerequisite for someone to be a legal person. A legal person, therefore, has the right to sue and be sued in law, and is able to have their rights enforced in courts. Hence, the notion of legal personality is derived from moral agency, which is regarded as having the cognitive function, autonomy, and intention to act in free will. A person is allowed to make moral judgment based on their free will, and in the same token, will be equally accountable for his choice and action. Despite that, we can draw analogy to corporations that are now widely held as artificial entities under Islamic law, based on a number of theories. Of course, there are divergent opinions on this, but recognition of companies as legal entities are widely accepted in many Muslim countries nowadays. In Malaysia, even, many companies are paying zakat, although zakat is only obligation on humans or individuals. Now, if I have the time, I want to talk a bit on the notion of incomplete person. The notion of incomplete person is not an alien term in Muslims' discourse. The prevailing view is that it should not be misunderstood that an incomplete person does and will never obtain any legal status. For example, in Islam, fetuses must be afforded certain human rights. This means a fetus is considered a person from the moment the ensoulment happens. The Quran has on many occasions touched on the rights of fetuses and the steps to safeguard their well-being. In the Muslim scholars' characterization of a person, biological considerations still remain at the top of the list. The lack of individuality in the fetus led some scholars to argue that despite the ensoulment, a fetus lacks full legal status. As the fetus is still growing, he or she lacks internal stability and numerical unity, and although he or she may feel pain, his or her senses are not fully developed. Yet in particular is cognitive abilities. The ability for rational thinking is what distinguishes a human from animals and other things. As for animals, according to Ibn Sina, they are considered as the creatures of Allah with soul. The only thing separating them from personhood is the element of intellect or rational thinking. The element of intellect is a distinct characteristic that defines personhood, as it allows a person to acknowledge its own existence without the assistance of all 5 faculties of the body. An animal does not have such capabilities in which, without their sense or smell and their sight, they are not able to understand the reasons of their existence, nor can they acknowledge themselves as being in existence. Now, slide 19 and slide 20 and 21 illustrate some of the Muslim scholars' opinion on corporation as artificial legal entities. Suffice to say that many views that the concept of personality is not only confined to natural person, as you can see in the quotation on the slides. Slide 22 contains examples of artificial entities recognized in Islam. Again, I need to draw a caveat that there are differences of opinion on this. Timur Quran and Wa'il Halak are among scholars who have different views on corporations as artificial entities. But as you see the list on the slides, you can see that perhaps some of these entities are recognized as separate personal entity, not for the purpose of personifying them, but actually for the purpose of ensuring there's a separate financial governance between a property that is developed or accumulated by these entities and the personal liabilities of the person managing them. To conclude, in Muslim discourse, support for artificial entities can be derived from an analogy of corporations, the concept of zimmah and ash-shakhsiyah al-i'tibariyah, or artificial legal personality. There are restrictions and conditions on the acceptability of these business enterprises and artificial entities. I will spare the detail for the shortage of time, but I am more than happy to explain if there is any questions on that. In response to Solom's inquiry, whether an artificial intelligence can become a legal person, I would like to quote Prof. Osman Zbakar's view on this. Prof. Osman is a renowned scholar in Malaysia, and in his column, The Clash of Artificial and Natural Intelligences, Will It Impoverish Wisdom? He said that artificial intelligence goes nowhere near natural intelligence of a human being. And when he used the term natural intelligence here, he refers to that part of the human comprising all his cognitive organs, physical and non-physical, together with their respective functions and activities in information gathering and organization for the purpose of knowledge, processing, acquisition, and understanding the ministries of human language. For him, there are two fundamental differences between human intelligence and natural intelligence, that is self-consciousness and self-discovery, as important psychological features that are integral to human nature. And from theological point of view, AI will always be inferior to human natural intelligence simply because it is man's creature. Most importantly, if there is a need to attribute AI as notional person to address the liability gap identified by EU Parliament and reports, there are rich discourse within Islamic scholarship that might assist the discussion. I am certainly in agreement with the expert group and EU Parliament resolution that we should seek to solve problems caused by AI by means of adaptation of the requirements of private liability without resorting to personhood for such agents. But in the event there arises a necessity to think of a separate legal entities, then there is plenty of discourse within Islamic scholarship on the position of artificial entities or personality. For those who are interested to read more of my views on this, I can share with you the draft paper that I did for Gulf Research meeting held in July here in Cambridge. Thank you for listening.